Alex here with part 56 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the underlying purpose as to the series of the channel, as to the purpose of the series, is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off with the last, I think, 2 parts in basically in my other case, the one against the Secretary of State. The previous video had to do with the filings in the Supreme Court of Nevada, and the one before that had to do with the court's order denying. And we are back now in the child custody action itself with my family court judge, as many people understand them. And at this point, my mindset is actually crystal clear. A lot of times I have trouble remembering 10 years back how I felt. And one of the exceptions happens to be a strong emotional memory, and I have a very strong emotional memory to what happened to trigger the filing that I'm about to go into in this video. This was not the first time that I was deprived of a visit, but this is the most inane time of them all. I think it does happen one more time after this, but I can't remember for sure if it's 1 or 2 more times. But anyway, what happened this time that really was upsetting was the fact that I showed up a literal minute late, if I remember correctly. It might have been 2 minutes, but I'm pretty sure it was a single minute late. I bet you that I mentioned this in the actual motion itself, but I haven't looked at it in advance, so I don't know. But I do recall being a single minute late, and the reason I say that now is because I actually remember when I pulled into the parking lot, seeing her car pulling out, and it was exactly as if she was checking her clock, waiting for that minute hand to go from 0 to 1. And as soon as it did, she was ready to just get out of there. So when I saw her leaving, it was really upsetting. It caught me off guard. I do warn people about this when they're dealing with a high conflict ex. The best thing that you can do is expect them to try to frustrate your parental rights or to do things that are inane like that. And that way, when it happens, you don't go bananas. And in my particular situation, I don't recall communicating with her in any way based on my sort of memory right now, but I wouldn't be surprised if when I went through the motion that I file that there's some kind of exhibits attached that do show that. So we're going to go ahead and take a look at just how I reacted. I don't suspect it was that bad, but it certainly wasn't to the point where I had gotten my emotions under control in, let's say, year 5, 6, 7. What I do remember, though, is my filing. I remember that crystal clear. I filed 2 motions. At this moment in time, I can't quite remember what I put in. Actually, yes, I do. So the video that we're going through right now is going to go into my motion to set a procedure for how to deal with this problem if it comes up again in the future. And the next video is going to go into the motion to modify child support. And I'm going to talk a whole lot more about my mindset in that video with regards to why her being 1 minute late triggered me filing a motion to modify child support. But the way that I felt at it in a nutshell is, okay, if she's going to nitpick about 1 minute late, then I'm going to nitpick about the law changing. And that's what happened. In 2008, the way that child support was computed changed. In 2009, the way that child support was computed changed from just a year prior, and it was only specific to people with joint physical custody like me. And I didn't bring it up. I just figured, whatever, I'm getting child support payments. I'm fine with it. I'm not going to nitpick over it. And then, well, she nitpicked over a minute. And by her nitpicking, for me not showing up a minute late, I decided to nitpick and modify child support. And it worked. It was modified in my favor. I do warn people from doing things like this in the video, Fighting Fire with Fire. It is something that can backfire on you. It didn't backfire on me, but I still want to warn my viewers that this is something that you don't want to do. I mean, if you have an opportunity to modify something, you should modify it when your case has merit. You don't want to time it with something like this because it can come off as you know, as I mentioned, as fighting fire with fire. It can make you look really bad. And again, in my particular situation, the modification of child support in and of itself did not backfire on me, but it is something that could happen to you, and I don't want to encourage people to do what I did in this particular situation. But all of this is going to be more of a discussion for the next video when I actually get into the motion to modify child support. But for now, we can go ahead and take a look at what I have filed in this video. Here we have the motion to set procedure for exchanges for imposition of sanctions, contempt of court, additional visits, modification of timeshare, and pretty much throwing in the whole kitchen sink. I am, just by looking at this document, starting to suspect that a whole lot more was going on than just my ex driving off because I was 1 minute late. And what I want to point out is maybe that was kind of the straw that broke the camel's back. Maybe there was a whole lot more that I'm going to recall as I go through this document, and I am interested to see just how much more was going on that I did not mention earlier in this video. As with my previous documents, I identify myself as the petitioner. I identify to the court that I am representing myself. I'm appearing in proper person. Table of contents, it's not common to include something like this in an ordinary motion. In fact, the court rules don't require it. The rules of appellate procedure do, but this is not an appellate paper. This is just a regular paper that's filed in a normal court, lower court, trial court, whatever you want to call it. And I didn't say that it's never used, because I have seen attorneys use this kind of stuff before in a motion. It's typically used when it's a very large filing, and in this particular case, it's a 54-pager, just based on what I'm looking at in this PDF reader. So it does kind of make sense as to why I'm using a table of contents, but I wanted to tell my viewers that it's not something that's always required, or in the case of Nevada, it's not ever required. It's just something that sometimes is done. Memorandum of points and authorities. Starting off with our factual background, I am pointing out that my ex and I share a common child of age 3, that we both share physical and legal custody jointly, that we exchange our son at Denny's, and that she has recently concealed her cell phone number, and the basis for her doing so is that I am harassing her. This is something that she states throughout the entire case. In fact, sometimes I joke to people that the magic word is harass. Now, I don't want to say it's magic as in it worked, because it, for the most part, was ignored by the court, but it's something that she would just continuously say over and over again, just because she thought that if she used that word, magically she would win. I do want to point out that the stuff that she would allege I was doing was provable. She would allege in court that I sent her nasty text messages or left her voicemails, or even that I called her and said stuff, and she was never able to prove it. And the thing that's weird about all that is text messages are in writing, voicemails are recorded, those should be provable. And if anyone recalls, the court did order that she was allowed to record me. So given that she had actually admitted to recording me in the past and brought it up at a hearing, it was always mystifying to me that she would accuse me of doing all of these things that were totally provable, but she would never have the proof. And I do recall bringing this up on a number of occasions, both in hearings and in papers. I would say, hey, she's accusing me of harassing her. Where's the proof? Where's the text messages? Where's the voicemails? And where's the recordings? Because she went through all this trouble to get permission to be able to record me, and then just magically would never record me when I was quote-unquote harassing her. So let's go ahead and continue on here. Next assertion is that my designee went to the exchange point, and that the designee and I waited until 3:11 p.m. She was late, and I could not contact her. So this is not quite what I recall. There must have been multiple exchanges here. So waited until 3:11. She was late, and I couldn't contact her. Maybe this was a time where she didn't show up. Or perhaps, well, let's continue reading. On June 11th, my designee and I, by the way, using a designee in these cases is not that uncommon. It's basically just showing up with a person who is going to exchange the child. Sometimes I wouldn't even show up with the designee. Sometimes it would just be the designee that would go get him for me. And the reason that I would do this is because if there's shenanigans going on, it's good to have a witness. And it's a horrible thing to have to go through in your custody case, especially when you have more than one exchange per week, because then you have to inconvenience a friend. But that's just one of the horrible things about these types of cases. If you're stuck with word versus word, oftentimes the court just is going to be very hesitant to believe you, and it helps a lot to have a witness. The other thing is that my ex would never know when I was going to bring a witness, so she would oftentimes, I suspect, comply with the court's orders just because she wasn't sure if I was going to come with a witness or not. And this type of gamesmanship is what you can expect in a high conflict case. So if you end up being in a similar situation where there's allegations that you're not showing up, that you are showing up, but you're showing up late, etc., you may want to consider doing the same thing that I did, which was to use a designee. Some people use recordings, but be very careful with that. Sometimes recording your ex at an exchange can backfire, especially if the child sees it and it causes anxiety. So to bring a camera and record exchanges is not necessarily the solution to a problem like this. I've had people suggest this to me before. If you are going to do that, you should do it surreptitiously. Surreptitiously in the sense that the child isn't going to notice and it's going to not be perceived as obnoxious. There are some states that do allow you to record your ex surreptitiously as long as it's not over the phone. Nevada is one of those, as long as it's in a public location where your ex doesn't have the argument that they thought that they had privacy with you. But it's the best way. I guess the better word than surreptitiously is inconspicuously. Anyway, we have the assertion here that I waited till 3:11, she was late, and I couldn't contact her. So I think that this is implying that she did show up and was late, and that I had no way to contact her because she kept her phone number from me. And then on June 11th, we have another situation where I arrived at 3:06 and she had left with him. I was informed by a third party not connected with this action that she dropped Army off with a sitter, and that I could not contact her, and that she could not, or that she did not contact me. She did not even contact me via restricted. Okay, so I'm seeing here that it's precisely 3:06, so I'm starting to think that my 1 minute late assertion is that she was required to wait at least 5 minutes. And I can't recall this off the top of my head now, but that does sound vaguely familiar, that we both had a 5-minute window. And so 1 minute late from the 5-minute grace period is what I think happened here. I still do think it's ridiculous. I know that there are a lot of people who think waiting even 15 minutes is considered reasonable, especially given traffic and how difficult it is to predict that. But 6 minutes after 3 or 1 minute after the grace period, whichever way you want to take it, I reacted with the filing of this motion and the motion to modify child support. So let's continue on. And by the way, yeah, we saw each other. So here's the other problem with it, is while I was driving in, she was driving out. So it was almost just rubbing it in my face that, hey, I see you, I see that you're here, and too bad, so sad, you're a minute late. Continuing on, argument in support of procedure for exchanges. So now I'm trying to ask for procedure. Pursuant to the order after hearing, the court has stated that we will have 5-minute window. Okay, so this answers my question. We are to have a 5-minute window within which to be late, and if either party violates the order, then the matter can be brought back to court on a contempt motion. Pursuant to the order after hearing, the court clearly states if either parent does not show up for exchange, he or she must notify the other parent as soon as possible, and will be required at that time to provide a phone number of a designee who will pick up / drop off the child. Okay, so this is where more of my being upset comes from, is that she didn't comply with the court's orders. Had she not willfully concealed her contact number, I would have been able to inform her that I was going to be a minute late and to hold on, because I could just pick him up a minute late rather than her driving off to another point. Since driving to the sitter and back to her workplace would actually take longer than waiting a single minute, it is apparent that the choice that she made was not out of necessity, but out of spite, which is true. She could have waited a single minute and then got to work 1 minute later than she would have been, but instead what she did was drive all the way to a third party, drop the child off, and then show up to work a whole lot later than just 1 minute later. So my assertion here is that she took the choice that was more obnoxious, that was more spiteful. Anyway, alternatively, she could have contacted my designee, who she was informed lived within 1/16 of a mile of her workplace, to drop him off, but she didn't. Alternatively, she could have contacted me after dropping him off, and she didn't. And I believe I'm bringing up the fact that I had a designee because, if I remember correctly, there was a court order that if a parent no-showed, the child would be dropped off at that location. However, she didn't want to do that. She, let's see here, cannot argue that she is perfect in punctuality because she herself has been 11 minutes late, 6 minutes late, etc. Which is true, and this is the double standard problem. I bring this up a lot. When you're dealing with a high conflict X, they will impose double standards. So, it'd be one thing if you were a minute late and you lost visitation and they were never late. But it's a whole different situation where you are a minute late and you're deprived of visitation when they themselves have been 11 minutes late, 6 minutes late, 10 minutes late, whatever. And that's the situation. It wasn't like she was perfect. She was late as well. Luckily, I didn't exercise the whole fighting with fire option. By the way, there's a video on the topic. So I myself didn't say, hey, since you're 11 minutes late, I'm just going to leave. She would show up late and I would still allow, the exchange to facilitate. But I want to tell my viewers that I don't regret having done that because it could have been used against me later on had I done something like that, because she would say, okay, fine, maybe I'm unreasonable, but so is he. And she didn't have that opportunity because I never did that to her. Next assertion here. I do not bring paragraphs 1, 2, and 3 to the court to quarrel. I understand that the court cannot order cooperation between the parties who refuse to cooperate. I bring these paragraphs to the court's attention to illustrate that this is not a problem of chronic tardiness. To the contrary, we share approximately a 1% rate of error when it comes to punctuality. I'm bringing this matter to the court's attention because it's apparent that she has turned this into a game of technicalities. So what I'm trying to tell the court is I'm not here to sort of nitpick about her being late. I'm trying to deal with a more serious problem, and in this particular situation, it involves deprivation of a visit with the child. And I didn't want my ex to turn this into, he's upset that he was a minute late and didn't get to see the child. I'm trying to point out that there's a problem here, a conflict problem, and that it's to the point now where it's actually affecting his welfare. And it's not even just being late and missing a visit. It's also the fact that we don't have a phone number. We can't communicate with each other by phone, stuff like that. It's more than just a simple, I didn't show up on time. Next assertion here. I am seeking a disincentive to the above-mentioned behavior. I am proposing that the court order the following regarding exchanges. A parent who has concealed his or her contact number from the other parent must call that parent restricted. So here I am trying to work around her dysfunction. I'm not even trying to say, hey, I want to know her number. I'm trying to say, okay, fine, she can keep her number concealed, but she needs to at least contact me restricted. Or, I don't know, there's certain ways to do this where a number will come up unknown or restricted. There's a third one. I don't know what that one is. Anyway, the point I'm trying to make is I'm not here trying to stalk her. If she wants to keep her number secret, it's fine. She just needs to at least reach out to me if something like this happens. Of course, I don't recall the court going along with this. I do recall the court ordering that. I don't think it's at this point that we use our family wizard, but it does come up. But anyway, I do want to point out to the viewers that I'm trying to put together another procedure. I talk about the whole, I don't want to talk about this all over again, but in my previous video where I tried to set a procedure on medical appointments and taking turns, I talked to the viewers about this idea that more procedures, more court orders, more behavioral orders, now in hindsight, 2019 version of Alex, me, or 2020 version of me, I'm not really convinced that that's the best way to go. I understand at the time I thought it was. I understand that at the time I thought the best thing I could do was get more court orders. But in hindsight, looking back over the last 10 years, I do think that the solution to a problem like this is a modification of custody. This is just an unsustainable way to care for a child. The approach to care for a child shouldn't be to continuously go back to court and get orders from the court telling your ex how to parent. It really shouldn't. If they lack the parental compass, if they don't have the correct instincts to do something like this on their own, I don't think that the court should tell them what to do. I think that the court should deprive them of custody, of legal and physical custody, because all this does is actually just perpetuate the conflict. And unfortunately, when you have a high conflict ex, they're just going to find other ways to violate the court's order, to push boundaries, to find gray areas. I actually have a great video on that topic. It's called Gray Areas. And I just wanted to stop for at least for a moment to tell my viewers that it might not be the best way to approach your case. To try and go for a procedure like I'm doing now in this motion and like I did in my previous motion is probably not the best approach. It might be something that you can ask the court to do in the alternative, but the main approach should probably be to have your ex deprived of physical and legal custody, or at least one or the other, depending on what's relevant to the particular dispute you're having. So anyway, let's go ahead and continue now. Next assertion here, I'm holding that the above order would provide a disincentive for us to avoid allowing the other parent to pick up the child, because the other parent will be able to go and recover the child from the sitter. This is true. If my ex knows that I can work around what she's trying to do, she just won't do it. So if she knows that she can drop him off at a sitter, but then I can go pick him up from that sitter anyway, then the way that her brain works is, okay, my goal is to keep him from having time with the kid. And if he can just go pick the kid up from the sitter, then my goal to deprive him of custody or to deprive him of visitation is going to be thwarted. Therefore, I'm just going to wait a minute and let him pick him up. And that's exactly the approach that I took throughout all those years, is I would find ways to make it so that I could work around her bad faith. And once I sort of set that up, she would actually stop using bad faith. It wouldn't be for the right reasons. It would be because she knew I could just get around it. And so once she knows I can get around it, once she knows I can defeat it, she doesn't even bother to do it in the first place. This will come up more in the case, but for now, this is just one example. Argument in support of sanctions. Throughout the entire custody case, her strongest shield against sanction has been ambiguity. Even the remotest form of ambiguity in a court order grants her confidence that her behavior can continue. This is true, and in fact, this is something that I talk about in detail in the video gray area. So I'm not going to talk about it too much right now because I have a video dedicated to the topic. But yes, if there is any kind of gray area, she will exploit it. And again, like I mentioned earlier in the video, it might seem like the best approach is to try and get rid of all the gray areas, to try and get everything as specific as possible, but it really isn't. There is almost no end to what they can do with a gray area or with their discretion, and so the best approach is to deprive them of custody. The next paragraph we have here is, this Nevada Supreme Court offers profound insight into cases with this level of uncooperativeness, and then I cite Mosley v. Figliuzzi, and the Supreme Court states that parental conflict almost always involves some fault on the part of each parent. To permit one non-cooperative parent to come in and get sole custody just because of a mutual conflict, it just rewards uncooperative conduct. And then I bold this portion here at the bottom that I'm going to bring up to the court that to hold or to permit one non-cooperative parent to get away with anything because of a mutual conflict just rewards them, and more importantly, actually deprives our child of the company of one or both of his parents. For example, while the order after hearing requires me to contact her if she is late, it does not restrict her from concealing her phone number to make it impossible for me to contact her. Therefore, she has in her mind justified her actions of withholding him and leaving him with a sitter because she knows I can't contact her because I don't have her phone number. Next, we have another example. She refuses to give me the address and names of the doctors and his insurance benefits card because it was not explicitly court ordered. That's true. I needed the names of the doctors, their addresses, and I also needed the insurance benefit card. And she didn't, give me any of that information because the court order didn't say she had to. So I had to file a motion demanding to have the information, which she opposed. And it was only after the court finally ordered for her to disclose that documentation to me that she actually gave me that number, or that documentation. Next assertion here. In another example, my car broke down and I was unable to take him to an exchange, and I called the Denny's to see if she was inside. She was, and I informed her that, hey, my car broke down, and I asked if she, could come and pick him up at a closer 7-Eleven or Wendy's. She refused, stating that I am required, pursuant to the court's order, to drop him off, and this was in the middle of December at 1 a.m. in the morning, which I don't know if anyone's been in Reno, but it is Arctic at that temperature in the middle of winter. So I'm just bringing up another exercise of bad faith on her behalf. Next, we have that her actions did not end, even after she received an order, which additionally stipulated that we are required, except in an emergency, to consult together before setting appointments. She refused. She made appointments without ever consulting with me and occasionally notified me, occasionally did not, and often when she did, it was 1 day's notice. So this is what I talked about in my video, denial of access to medical care. I do mention in that video that first she wouldn't tell me anything about his medical care. Later, when she was ordered to, she would tell me stuff, but she would wait until the last minute. She was still trying to frustrate my ability to appear at these appointments. And I am mentioning here that I had to affirm this order with another order requiring her to give me 14 days notice. And kind of just explain where that led off to, because that's another motion with another hearing with another order. And now she has to give me 14 days notice. It's, of course, another example of bad faith. Just after the first interim order, she refused to appear at an exchange point on time twice. Both times she was an hour late. I don't remember this. I tried to have her held in contempt of court. Oh, this was the one that was way back. Yeah, I do remember this. This one was so far back I almost forgot about it. Next, we have that it is impossible for the court to seal every hole of ambiguity. I believe that at this point sanctions are essential. If sanctions are imposed, she will understand that the penalty for taking uncooperativeness to such an extent will not be acceptable by the court. Pursuant to the law, one of the acts or omissions deeming contempt of court is disobedience or resistance to any lawful writ. So what order is she let's see here, what order is she violating? Because this is true, this is the law, and she does have to abide by the court's orders or she can be held in contempt, but I need to see precisely what order she violated. I'm providing the court with 2 affidavits of witnesses, including an affidavit in support of contempt, and my witnesses are prepared to appear at a hearing to testify. It's important to bring this up. A lot of times these courts think that if you're not an attorney, you don't know what you're doing, and they think that you aren't going to bring any witnesses, even though they've prepared affidavits. And I like to let them know. I'd let the judge know, hey, I've got an affidavit, and I know I need to bring this witness to court. I know this. And I think it's because just a lot of times somebody will file something like a letter or an affidavit, and then the hearing comes, and then they won't bring the witness. And a lot of times people think it's just because they can just use the letter or the affidavit or the report or whatever. In Nevada, you can't, and I explain why in a video titled Hearsay. In other states, you actually can do this. So definitely look into the video Hearsay, and definitely look into your state's exceptions. Pursuant to the law defining the penalty for contempt, I'm requesting that the court impose a sanction of $250, so I'm basically asking for a fine. And I'm also asking that she should file a receipt to prove that she actually paid the fine. Argument in support of... Okay, let me stop here. I don't recall a specific order being violated, and I think that's why contempt does not get imposed. The order requires me to call her. It doesn't require her to call me. And the order doesn't require her to give me a cell phone number or to keep her cell phone active at all times. So she has done things that are in bad faith, but she hasn't specifically violated an order. And this is one of the things I talk about in the video, many fine lines. Oftentimes, these types of exes will find ways to abide by the court's orders literally, like they'll follow the literal letter of the court's order, and they end up getting away with it because, according to the law in pretty much all states, contempt of court is violation of an order. It's not doing bad stuff. You have to show how they were ordered to do something and they didn't do it. If you try and say, hey, they did stuff that was unreasonable or that was bad or that hurt the child, that's not contempt. That is a basis to modify custody. And that's what I talk about in the video, Many Fine Lines. But it's not contempt. And I urge people who are going through this to watch that video because there is a silver lining. There is an approach to solving that type of problem, to defeating that type of tactic, but I don't want to go into it in this video because I already have a video dedicated to it. The next portion here is that pursuant to the law, in a dispute concerning the rights of a non-custodial parent to visit his child, the court may, if it finds that the non-custodial parent is being wrongfully deprived of his right to a visit, enter a judgment ordering that I have additional visits to compensate. And that's just the make-up visitation statute. It allows the court to say, hey, you were deprived of 10 days, so I'm going to give you 10 days. Next, we have that my ex wrongfully deprived me of 2 days. Next, we have that in this case, I refer to the existing vacation procedure outlined in order after hearing. And since we are entitled to a total of 15 days of vacation, I'm simply requesting the court grant me an additional 2 vacation days. That's a really smart way to tie in make-up time to a procedure that we already have. Basically, I'm saying we have 15 vacation days. For my make-up time, I would like 2 more days this year. Total of 17 days. That's it. Don't have to have a whole separate order with a whole separate process on getting the make-up time. Just tie it on into my vacation days. Smart. You should do the same thing if you have that opportunity. It shows you as a solution-oriented parent. Next, we have argument in support of modification of timeshare. Contingent on education. The current weekly timeshare contains a gap of time, henceforth gap, from Friday at 12:30 a.m. to midnight to Friday at 3 p.m. So the same day, basically from 12:30 a.m. in the middle of the night to 3 p.m. that same day. Within the gap, She has him before and after the gap. I have him. I'm worried that when he begins to attend school, this will be disruptive to his sleep, which it will. The court has maintained that it does not want him to spend a large period of time apart from either of us because of his age. However, I'm holding that when he begins school, he will be 4 and significantly more understanding. Additionally, the court's argument holds a double standard against me. A majority of time within the gap, he is asleep and he can benefit from just not being woken up. And according to the law, Rivero, the Supreme Court has stated that adjusting a residential timeshare in a joint physical custody arrangement is appropriate when it's in his best interests. And in this particular situation, I don't think it's deniable that not being required to be woken up at midnight to be exchanged for just a few hours is going to be in any way harmful to him. In fact, it's going to be in his best interest. Additionally, I'm understanding that a change of circumstances should merit consideration of this adjustment, hence the contingency. Making this order on the contingency prevents the filing of a motion at a future date. And I'm assuming that the contingency is when he starts school. Yeah, next paragraph, that's exactly what I say. As soon as he starts school, I would like for the visitation to change automatically. Basically, I'm trying to tell the court that this is a problem we could solve now rather than later. I don't believe the court goes for it. I do believe that is because we settle this particular couple of motions. But I do eventually get this request granted. It just happens later on in the case. Argument in support of order to send information to welfare. Having lost my original job at Circuit City, I don't know if any of you know this, but Circuit City went bankrupt, and I was there when it went bankrupt. I had to apply for food stamps benefits for myself and our son. The Department of Welfare requested information from my ex on 2 occasions, and both times she just ignored them. Next assertion here, let's see. The court has the authority pursuant to the law, where the law clearly states that when the court enters an order pursuant to subsection 1 for the support of a minor child, or children, the court shall ensure that the social security numbers of the parties are provided to the Division of Welfare and Supportive Services of the Department of Health and Human Services to issue a writ of mandamus commanding the clerk of the court to send the social security numbers of the parties to the Department of Welfare. Oh, I know why I'm asking that. I'm asking that because we both would have had to submit this information to the clerk of the court in this thing. I forgot the name of it, but I think it's called a confidential information sheet or something. When you file something in one of these cases, you file one of these confidential sheets that has that kind of information in it. Anyway, basically, I'm telling the court, hey, the law here requires that the Department of Welfare know the social security numbers of the parents, and I think it has to do with child support. But anyway, I'm asking the court to issue mandamus and command the clerk of the court to send that information to the Department of Welfare. I think that what happens is when we settle, my ex's attorney just tells her, hey, you need to send this to welfare, stop being unreasonable. And by the way, I don't think the court needs to issue a writ of mandamus to get what it wants. In a situation like this, I think they can just enter an ordinary order telling the clerk to do whatever it is that the clerk needs to do. If anyone wants to know what a writ of mandamus is, please watch my video, Writ Petitions. It's dedicated to the topic, and I'm not going to go into it since I have a video dedicated to it. I'm requesting that my ex be ordered to cooperate with the Department of Welfare. Next, we got the hearing portion here. I'm requesting a review hearing on this matter regarding, I shouldn't say that, I should say evidentiary hearing. I'm probably asking for a review hearing because I've seen the court do that a few times in the past and it worked out rather well. I don't think that, I guess parties can request those types of hearings. I don't see what the point would be. It would kind of be up to the court whether or not they want to do something like that. What you're kind of asking for anytime you file a motion is an evidentiary hearing. You're always, I mean, as I mentioned, for the most part, you're asking for an opportunity to prove what you're asserting in the motion. Whenever you file a motion and it contains allegations, what you're asking for is an opportunity to prove those allegations. So that's not something you can do at a review hearing. That's something you can only do at a trial and or in evidentiary hearing. See, look at this. I'm already saying that witnesses are going to appear. You can't have witnesses appear at any other hearing except for a trial or an evidentiary hearing. So I just don't know that. I'm requesting that the court order parties to exchange witness lists at least 10 days prior to the hearing. I am requesting the court order us to a limit of 20 interrogatories. Okay, so I should make this request under the Nevada Rules of Civil Procedure. I shouldn't do it like this. There is a court rule in Nevada that talks about post-judgment discovery. And when you're trying to get post-judgment discovery, what you want to do is cite the rule. And if there's any precedent, cite the precedent. You shouldn't just kind of wing it like I did here. Next request is that the court order us, I should mention a couple other things. If you don't know what interrogatories are, please watch my video on interrogatories. If you don't know what, I guess that's the only thing that I mentioned here. Oh no, my next paragraph, I mentioned requests for admissions. Same thing, I have a video on that topic. And I also, let's see here, disposition, court order dispositions of witnesses to be filed at least 10 days before the hearing. Oh, depositions? That might be what I meant to say, depositions. I don't see what I mean by dispositions. Anyway, if you want to know what a deposition is, I have a video on that topic as well. I also have an overarching video on discovery tools called Discovery. So if you don't know what any of those things are, they are basically the various different tools that a litigant can use to conduct discovery in a case. So it would be a good idea for you to watch the video Discovery if you want to learn sort of the point behind all of that and the approach that you should take. Conclusion. I am requesting, I'm basically going through a summary of everything that I asked for. I'm not going to go ahead and reiterate it now. But as with all my previous videos in the My Docket series, if you look down in the description below, you'll see links to these documents, and you can always click on them, download them, and then if you have questions on things that I didn't cover, you can put it down in the comments below, and I'll answer your question to the best of my ability. Affidavit, and this is required by court rule, and it is required because all of the allegations that you are making in your motion, all of the fact-based ones, need to be sworn under penalty of perjury. And that's what this affidavit does. It ties everything that you're accusing your ex of to, it makes it also, it's sworn under oath. Here we have the affirmation pursuant to NRS 239B. I've talked about this many times. It's required, at least it was at the time. I haven't double checked this in a long time, but there's a law either now and before, or maybe it's changed now, and it used to be a law that required this sentence to be included in any of these filings, because the clerk of the court would not have the real resources or the time to have all of their deputies look through all these filings and look for social security numbers on their own. So the next best thing was to just get the person who was filing it to, swear under penalty of perjury that the particular document in question did not have a social security number. So rather than them check all of your papers, they would just look for this sentence, and then they would just take your word for it. This is the motion opposition notice. Nevada requires these, at least District 2 did. And I'm not sure now if all of the districts require this. District 8 does as well, but it looks different. The form doesn't look the same. Anyway, the point of this form is to have the person who is preparing the filing check specific boxes, which will basically tell the person filing this whether or not they have to pay a filing fee. At the time, it was $25, and it was only if certain boxes were marked here. In this particular situation, I am alleging that I am not trying to change a final order, and therefore this is a free filing. I'm not really sure if that's the case. I always imagined that asking the court to enter a new order wasn't a modification of a previous order, but now I have serious doubts that that's actually a correct understanding as to how this is supposed to work. I think anytime you have a final judgment or a decree of divorce, anything that you're trying to do after the fact seems to me to be an attempt to modify that. And I don't know, maybe I'm wrong about that. Maybe there's somebody who has some insight on this and they can post something down in the comments below. But as far as I know, I probably should have been paying $25 filing fees. I just didn't understand it at the time. Okay, so this is the self-help form. If you're including an affirmation in a custom paper, you don't have to include this self-help affirmation as well. It's superfluous to have two of them. So it's here probably because on one occasion I was rejected or sent away by a clerk of the court, and I just wanted to play it safe going forward because it's a waste of your time and money to get sent away from the courthouse. But now as I sit here and I look this over, this is a superfluous piece of paper. I didn't need to include it. List of exhibits. So we got 9 different exhibits here, and I'm going to go ahead and go through them. I'm not going to go through all of them. For example, if you look at exhibit number 1, that's the order after hearing that I've already gone through in the series anyway. So if there's a document that I have already gone through, I'm going to just skip through it. But if there isn't, I'll go ahead and glaze through it. Maybe if something jumps out at me as useful to the viewers, I'll address the exhibit, but otherwise I'll move on. And as I mentioned earlier in this video, you can always go down into the description, click the link, download it, and look through it yourself. If you have any questions, you can always post it down in the comments below. Exhibit 1. This is required. If you don't have these separation sheets, they will reject your filing, and you'll have to go all the way back home. And well, nowadays everything's e-filing, so I guess it's not that bad. You'll just have to adjust your PDF so that it includes these separation sheets. Okay, so this is the order after hearing. I've already gone through this before in the My Docket series, so I'm going to move on. Exhibit 2. This is another order, another document that I've already gone through in the My Docket series, so I'm just going to move on. Exhibit 3. This is a motion that I have filed quite some time ago, and this is the one where I'm asking the court to set a procedure. By the way, guys, I don't think it's really necessary to include things that are already in the docket as exhibits in new filings. I think it's probably fine to just reference the date that you filed that document. So if you reference the name of the filing and the date that it was filed, it should be good enough for the court to go back and take a look at it. You shouldn't have to include it as an exhibit. And I do start to do that way towards the end of my case. So we're talking like years 6, 7, 8. I stop attaching these filings as exhibits because they're already in the docket anyway. So since I've already gone over this, I'm going to skip it. Exhibit 4. Opposition to motion. So we've got an opposition to the motion that I just went through. Again, this is a document I've already gone through in the My Docket series, so I'll skip it. Here we have Exhibit 5. Order after hearing. It's a document I've already gone through. Let's go ahead and skip that. Exhibit 6. Here we have an affidavit, and this is the affidavit prepared by my designee. I'm going to just take a really quick look at this. Let's see. She's being asked to answer an affidavit. Please respond to the questions of which you have personal knowledge. Whenever you do not have personal knowledge, please state as such in your response. These questions must be answered truthfully under penalty of perjury. Okay, so these are, I'm going to just kind of glaze through these questions. I want to make sure that they're just fact-based questions. Some of these questions are pointless. It doesn't matter that she has no kids. It doesn't matter that her gender. Residence, I guess, for the purposes of like having her appear in court to impeach her. In your own words, how well do you know? Have you met him? What's the relationship? Friends? How would you describe honesty? Okay, so this is so subjective. And you also can't have a witness testify as to the credibility of another witness. It's actually forbidden. So that would be a question that would be a thing that there's no point putting it into an affidavit. How would you describe relationship with his son? Again, so this is an opinion on how good of a parent I am. Some attorneys will even bring this up in a case, but I think it's so weak because it's a friend of yours. Of course, they're not going to say that you're a bad parent. And if they did say that, you just wouldn't even have them prepare an affidavit, or you just crumple it up and throw it away. So this kind of stuff is pointless. Don't ask this stuff. By the way, I get a lot better at preparing affidavits towards the end of my case. So this is the first one that we've gone through, and it's not the worst one ever, but there are definitely things in here that are pointless. Do you believe do you believe him to be vengeful or vindictive? Not at all. Again, this is going to have no weight in court at all. Pointless question. How well would you say he treats his friends? Pointless question. Has he ever behaved in the remotest violent matter? Pointless question. It's not relevant to what we're doing. Another irrelevant question. I think these have to do, I don't want to pick through these. If anyone wants to look under these, I think these have to do with parenting, like if I'm a good parent, stuff like that. Pointless. This one says it's narrative. Pointless questions. I'm not even going to redact them any further. If people want to like try and take a peek underneath those questions, it doesn't matter. Describe our son. Again, like we're talking about whether my ex was late at an exchange. So this is not really going to help the case. June 11th, here we go. Okay, so now we're starting to get to stuff that matters. On that specific date, did you accompany him to an exchange? Yes and yes. How often did you make this trip? It says too many times to count. How often did you personally make the trip? 3 times. So personally, that makes me think that I am referring to her going without me there. And this is something that I mentioned earlier in the video, that there were times when we would just send our designee and we wouldn't even go with them. Both her and I would do this. How do you know her? She doesn't know her personally. On June 11th, when I and the designee went to Denny's, was she there waiting? No. On June 11th, when I returned to the vehicle without him, where were you waiting? All of these questions that follow this point, these are relevant. These are good questions. These are the ones that should have been in the affidavit. I didn't need any of the other questions. She basically supports everything that I've asserted in the motion. I'm going to glaze through these because there's no point in going through each one by one. And again, as I mentioned, this document will be down in the description below if you want to download it for yourself. So yes, the last thing that I would like to say is the questions that basically start going over the actual exchange itself. Those are the questions that should have been in the affidavit. All of the other questions were pointless. There was no need to any of them being in there. And as I mentioned earlier, I do prepare affidavits that are a lot better later on in the case. And it is a good habit to get into, because when you include affidavits with your motions, you stand apart from the other people who are representing themselves that don't know how to do that. So it does make you stand out. And of course, it helps if you prepare affidavits that are actually relevant, that don't contain questions that are a waste of time or that the court doesn't care about. Verification and acknowledgement of the person who prepared the affidavit. I don't really know why I called it that. It doesn't really need... It just needs one single sentence that says that this document is being prepared under penalty of perjury. So this is a little bit over the top. It's nice that we have a notary that's stamping it, but we don't need any of that. That could have been done by declaration in lieu of affidavit. I have a video that explains what that is. The video is titled Affidavits and Declarations. Take a look at that. Exhibit 7. So we have another affidavit, and I'm assuming that this is going to be similar to the first. I'm going to glaze through the first few questions because I'm seeing the same problem. It's involving things that are not relevant to the case. I'm going to continue. See, this is just stuff that goes to my character. Stuff that's random that hasn't even been asserted, like alcohol consumption hasn't been asserted. Controlled substances hasn't been asserted. A bunch of pointless stuff that asks her to key in on my credibility, that's not allowed. Let's see here. None of this stuff is relevant. None of that was relevant at all. So a completely pointless affidavit that it basically, these are, hey, he's a good person, he's a good parent style affidavits. There's no point to these affidavits at all. I know that I've mentioned that sometimes lawyers will use them as well, but in my opinion, they take it with a grain of salt for the reasons that I mentioned earlier. If you get an affidavit that's bad, you just crumple it up and throw it away. So they know that these are one-sided. They know that they're only going to get stuff that's favorable to you, because if it's not favorable, you'll just conceal it. You won't include it in your filing. And so that whole entire affidavit was pointless. As I mentioned earlier, it's going to be down in the description below if you want to download it and read it for yourself, but I'm not going to go through it in the video because it doesn't impact the case. Exhibit 8. Okay, so this one is an email from me to my ex. How do you expect me to be nice when you keep him from me? It's not even as if I'm being disrespectful. You've been late 11 minutes and 18 minutes before. So I'm bringing up the double standard here. I'm late 6 minutes and I don't have your number. You could call restricted. So this type of communication, it's pointless. I mean, it is a good idea to at least convey in some way that you don't approve as to what's occurred. But anytime you try to sort of get them to put themselves in your shoes, anytime you try and get them to sort of understand that you're suffering, it doesn't usually help your case, because as I mentioned in my video communication, and as I also mentioned in my video hide emotions from abuser, they get off on all of this. So they don't need to be told that what they're doing is harmful. They already know it is. And they aren't going to feel bad about it. In fact, they're going to feel better. And I talk about that more specifically in the video hide emotions from abuser. A lot of times when you're dealing with this type of person, they're sadistic. And so when you tell them, hey, this affects me, this hurts me, I'm suffering, they just get off on it, and it makes them want to do it more. It doesn't make them want to do it less. So I have my other video communication where I explain that you need to communicate enough that the court is going to review your communication and consider it in a way that is beneficial to your case without going any further than that. So you want to avoid emotional stuff. You want to avoid trying to get them to understand your point of view or trying to explain to them that what they're doing to you is harmful, because they already know all those things. They already know it's harmful. You're not teaching them anything new. They don't care, or they do care and they're going to keep doing it because they know now that it's working. Again, as I mentioned earlier, you can look through this email if you want to, but it's just a typical reaction from a parent who is frustrated and doesn't understand that the other parent isn't clueless, that they are perfectly in tune with what they're doing, and they're doing it on purpose. So let's scroll down here to Exhibit 9, affidavit in support of contempt. Let's see here. So this is actually an affidavit that mirrors everything that I've put in my filing. The only thing that I'm going to say about this affidavit is it is required under Nevada law. If you are trying to have a person held in contempt of court and they have committed that contempt of court outside of the presence of the judge, which is what happened in this particular situation. Inside the presence of the judge is like while you're in court face to face with the judge and you flip them off or you call them names or you throw something, that's contempt inside the presence. Contempt outside the presence is everything else. And anytime you try and hold somebody in contempt for something that they've done outside the presence of the court, you have to file an affidavit. It's a jurisdictional problem if you don't do this. What I mean by that is, if you don't do this, they totally and utterly lack the power to do anything. So the affidavit to have your ex held in contempt of court, or sorry, what I should say is the affidavit in support of the allegations that are made in the motion to have him held in contempt of court is crucial, it's jurisdictional, and it goes to the authority of the judge to even consider what it is you are asking for. It's a fundamental requirement in Nevada. This affidavit, as I mentioned, is going to mirror this filing. And so I'm just going to be reiterating things that I've already stated in the motion itself. So I'm going to go ahead and skip through it. But as I've mentioned earlier, fear not, because down in the description below, you can just click on the link and download this document for yourself. And of course, if you have specific questions, you can always bring them up in the in the comments below. Here is an affidavit. What? Why? I've already prepared an affidavit up here. I don't know why. It's just me copy pasting, I think. I don't really understand how any of this works, so I just took that same affidavit that was in the motion, copied it, and pasted it down here. The affidavit's already an affidavit based on what I titled it prior. I don't need this extra paragraph to be included at the bottom of this. Going into the aftermath, I filed this motion. However, based on the motion opposition notice that I filled out, it's a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have had to review this document, and she would have also had to confer with her client. It is a big document. To review the document probably took her at least 15 minutes. And to communicate with my ex probably took her at least 15 minutes. I'm not going to put all of the time that went into her resolving this issue into this review right now, because I do believe she files a stipulation later, and I will go ahead and put more time into that particular filing. But I think for just this motion and to just communicate that I have filed a motion, we're going to put the attorney fees at 30 minutes, which at a rate of $250 an hour is going to come to $125. And as I mentioned many times in this video, definitely feel free to post something down in the comments below, and I will see you guys next time.